Good afternoon, and welcome to today's program, a conversation with PERB Chair Tim Connick, sponsored by the Labor and Employment Law section of the New York State Bar Association. Today's program will run from 12 p.m. to 1 p.m. Please note that the chat function has been disabled. If you would like to pose a question to the speaker, please use the Q&A box in the Zoom portal. At the conclusion of today's program, please head to the My Learning dashboard to complete the course evaluation. The speaker's biography and course materials can also be found there. If you need any help accessing the My Learning dashboard, please refer to the instructions in the program email that you received this morning. At this time, I would like to introduce the Vice Chair of the Labor and Employment Law section, Abigail Levy, to introduce today's speaker. Abby?
Thanks, Emily. So welcome, everyone. As Emily said, my name is Abigail Levy. I am the chair-elect of the Bar Association's Labor and Employment section, and I'm also Deputy General Counsel at the New York City Office of Collective Bargaining. Before I introduce the chairman, I want to give a quick plug for the annual meeting this year. The Labor and Employment section's annual meeting is going to be on Friday, January 17th, and we'll also have some meetings the day before on the afternoon of Thursday, January 16th. So I would encourage you all to come. There'll be CLE, of course, and it should be an interesting set of plenaries and workshops. So I am very happy to introduce Chairperson Timothy Connick from PERB. Chairperson Connick was appointed to serve as PERB board member chair in June 2024. He's been an attorney for over 40 years, devoting his practice almost exclusively to labor law and employment litigation. Prior to becoming chair, from 2011 to 2023, he represented New York State United Teachers and was senior counsel in Western New York and on behalf of the Buffalo Teachers Federation. Whoops. Can everyone mute if you're not muted? Prior to that, he represented the Civil Service Employees Association, holding the position of deputy counsel and director of statewide litigation for a number of years. Prior to that, he worked for the New York State Department of Labor. And then prior to that, he was in private practice. And Chairman Connick is a graduate of Cornell ILR and Albany Law School. So with that, I will hand it over to the chair. And thank you so much for being here.
Thank you, Amanda. Good morning or afternoon. I am sort of gratified by the turnout. We had quite a few people sign up. I think the price was right, but I thought it would be helpful to have a conversation with public sector litigants about how to make PERB better. I thought it'd be helpful for litigants to hear what we've been doing and what our focus is on right now to make PERB better. The agenda is a little bit off. It says that questions will be taken in the last 5 minutes, but I encourage people to ask questions throughout, whatever I say, and comments, and we'll try to address them. I have a box on my screen over here that will have the questions. Now, I'm going to be talking about what we've been doing, but I'm also at the second half of the conversation. I'm going to talk about what our PERB people have suggested could make your litigating at PERB work a little smoother. What I did in terms of the second half of the conversation is I surveyed our staff as to what they find the best practices are that make things work the smoothest for them. And I thought if I told you folks, it might help the whole process. But just first off, the first part of the conversation, that is what we've been doing. I came into PERB in mid-June. as Abby mentioned. And my background, I think, is a little different than a lot of the prior chairmen, and most of the prior chairmen, maybe all the prior chairmen. And that is, I've been litigating before PERB as a party, as an advocate for the past 30 years or so, more than 30 years. So I've been a customer of PERB, so to speak. I've been observing over the years how it works, and I have a perspective as a consumer, a customer. I've never been in PERB, unlike working within the organization, unlike most prior chairpersons. I come at this strictly as someone who is looking at what is it that customers, users, litigants find useful about PERB, and what have been the issues with PERB. And from that perspective, my biggest issue, concern coming in was the delay in getting ALJ decisions. When I started litigating regularly at PERB some 30 plus years ago, we would get a decision in a case from an ALJ within 2 or 3 months after we submitted our briefs. In recent times, it takes sometimes 2 years, depending on where the case is located, to get a decision, sometimes more than 2 years. Certainly, very seldom would we get prompt decisions. Now, from my point of view, and I think for most people, because I've had these conversations with both. Now, as an advocate, I was working with on the union side, but I've heard management side people who have agreed that this is a problem. This isn't in labor relations of all fields. It's not helpful to have issues that come up that don't get resolved in a timely fashion. It's not fair to the unions or the employers. For the unions, if there's a wrong that's been actually done, they don't get a remedy. Sometimes if you don't get a reinstatement or back pay for 2 years, that's not much of a remedy in a say, retaliation case. For the employers, they're trying to get their job done. Have these allegations hanging over their head if they're innocent is not a productive thing at the workplace, to have these issues floating out there. And then if they happen to be found to have committed a wrong, they can get hit with back pay and exorbitant, I shouldn't say exorbitant, the legal rate of interest, which is very high, for an excessive period, which wouldn't be the case if these decisions were issued in a timely fashion. So as I say, my biggest concern has been with the efficiency of the litigative process in terms of how fast ALJ decisions get out. Now, as an observer of PERB for decades, I think the doctrines that PERB has enunciated over the years are sound. I think my observation is in recent years, the board has been sort of eccentric in the application of those doctrines, but those substantive kind of issues, they can be handled on a case-by-case basis moving forward. But this issue about the delay in the ALJ decisions, this is an issue I think the system is broken and it's got to be fixed. So when I came in, my concern was immediately, right away in June, to start an intensive discussion with staff about what causes this problem. And then when we know what the causes are, how can we fix this problem? Now, I was looking at and was talking about some radical solutions, and I was thinking about maybe form decisions, maybe bench decisions, maybe summary decisions, short, 2-page, 3-page decisions, that sort of thing, if that's what it was going to take. Now, the staff here, I think most of you, I hope most of you will agree that you found that the staff is dedicated and they're hardworking. And they were, most of them, maybe all of them, but most of the ones I spoke to were equally concerned about the decision delays. They were equally concerned that it was tainting PERB's reputation. It was making this agency putting it in a bad light. And as dedicated PERBers, they don't want that. They want this agency, I would say, it's got a fine kind of a admirable history as being a leader, as New York often is in labor relations, as being a leader among public sector agencies. And we want to maintain that. We want to reestablish that. So I immediately found, and this was gratifying to me, that the staff was very conducive and receptive to the idea that we have to improve this. Now, what caused the problem? And most problems, there wasn't a simple answer. It wasn't one thing. One of the major things, logically, and I'm not going to be saying any, Einsteinian things, was staffing. We had situations where we had vacancies that didn't get filled. We had turnovers, people who came and left in a relatively short period of time. We had a situation which many of you may be familiar with in the Brooklyn office, where we had one ALJ for an extended period of time. And given the work that would come into the Brooklyn office, that's an impossible situation for anyone. We had, at one point in our Albany office, all the ALJs were new and learning, and that's a difficult situation. And the problem when we have turnover is an ALJ leaves and they have cases they haven't decided. There's nothing worse. Well, I'm sure there are some things worse, but it's a bad situation for a new ALJ to come in and get a case that they hadn't been the hearing officer, and they're trying to understand what's going on and get a feel for what's going on. It's not a good situation for a lot of things, for a lot of reasons. Now, to throw in the staffing issues, we have there are other issues that just throw fuel on the fire. We have an antiquated computer case management system. We had internal bottlenecks within our system between the writing of a decision and the actual issuance of it. And frankly, I don't think the issue was really given a priority, this delay problem with top prior PERB leadership. The priorities were on other things. So the question comes up, how do we fix this? And in July, we implemented 12 different things to get this fixed. Now, none of them are radical, and they're all commonsensical. The concern was, and it made sense to me, if we resort to bench decisions, summary decisions, it's really changing the nature of how PERB has done things, the thoughtful ALJ decisions with, careful reasoning and so forth. And it would also make things difficult on exceptions. When you go up to the board, if there's a full record below that's described in the decision, it makes it easier to follow what the exceptions are all about. And, there's a ripple effect. When you change one thing in a dramatic way, you're going to have a impact on other things. Now, my staff has assured me that we can do this with non-radical decisions. We implemented these, as I say, in July, and we're going to see where we are in 6 months. In January, we're going to look at this and see, are we making some headway on this? And if we are, we're going to continue. If we're not, we're going to reevaluate, and maybe there's going to be some more drastic things we're going to do. But let me tell you what we have done. The first thing is we got to fill vacancies. I guess that makes common sense, and we're in the process of doing that. We want to maximize the amount of ALJs we have, and we did some juggling. We've created a new ALJ position for upstate, and we're in the process of filling that. We made an offer on that yesterday to someone, and as I say, we're in the process of filling that. We're going to do some more in terms of, we hope, budget-wise, in terms of maximizing the ALJs that we have. That's an obvious common sense thing. The more ALJs you have, the less their particular specific workload, the more they can devote to each case, the quicker they can get the decisions out. Now, we have instituted a system where every older case now has a specific deadline. And we are having monthly compliance meetings to see that those deadlines are met. And we have a focus now on getting decisions out in a timely way and getting the backlog completely erased. Now, this is as everyone here knows, this is a priority for me. This is one of in addition to what we have to do in the private sector, getting that on track, which that's a whole different conversation. This is a priority to get PERB operating efficiently again. Now, I'm told that with the system we have implemented, that we can get rid of the bulk of our backlog by December and substantially eliminate it by March. Now, are we going to be able to do that? I don't know. Now, in addition to having deadlines, I should add, where we have an ALJ who's particularly backlogged or swamped, we've instituted a situation where we have other staff people assisting in the summarizing of testimony and in research to tee up those decisions for the ALJ, who actually was the hearing officer, to come in and then just write the decisions. So it's a whole system of support to get the backlog eliminated. Now, as I say, we're talking about a substantial elimination, hopefully the backlog by March. So that's the goal. Now, I know other PERB people in the past maybe have shot for that kind of thing and haven't been able to do it. I hope we can do it, but as I emphasize, beating a dead horse, it is a priority. We have some other long-range things that we've done. We're working on a whole new computer case management system so we can watch this more carefully. We had some bottlenecks in the past internally insofar as, the decision's actually written, but then it doesn't actually go out. And we've eliminated that, to know the specific details as to that kind of thing, but we've eliminated that. So that's where we are right now in terms of dealing with the deadline. Now, our goal at PERB is, and I've said this before to our staff many times, our goal is at some point next year, mid to late next year, it's realistically speaking, it's probably going to be late next year. I want ALJs to be able to say after hearing that you will get your decision, barring unforeseen circumstances, within 60 days. And that's what that is the goal. And I think that if we can do that, then we're back on track. Now, there's some other things that you should be aware of that we've done that maybe can make this process a little smoother. Conferences now, the pre-hearing conferences are supposed to be scheduled within 4 weeks of when the ALJ gets the decision, subject to the ALJ's schedule. And of course, the parties may want to juggle that, but we're looking at when we get the case to get it on track sooner and faster. Some little tweaks. It used to be, it still is, I presume, where after a case is concluded, the parties always want to file briefs, and it was almost considered a requirement. I always thought it was a requirement that you had to file a brief. Now, you do have the right to file a brief if you want, a closing brief, but summations now are okay. ALJ will accept summations. Now, I always wanted to file in non-PERB cases, generally speaking, I say always, generally speaking, a closing brief. And then I found as an advocate, a few times I was forced to do summations, and it was great. It was, in addition to saving a tremendous amount of time, it was effective, I felt. So, I think most PERB litigants might be a little reluctant to go with summations, but it will speed up your case fairly dramatically, I think. And now, of course, you know, if it's really complicated, you may want to file a closing brief for the ALJ. There's some issues that they're wrestling with. They may want one. Or, of course, if the other side is insisting on a closing brief, you may want to do a closing brief, but be open to that possibility. Another thing, too, I want to mention is that we have in the past given priority, as you folks probably know, to representation cases and to scope cases, you know, negotiation scope cases. We've added to that to tell or demand for information cases. The ALJs have been advised to try to give them priority. The reason for that is if you're negotiating and you need information, either side, or if you've got a grievance you're processing or trying to prosecute or defend, or you have a disciplinary case that you have a right to tell or demand for information. If it's going to take 2 years to get a decision out of PERB, that's a worthless remedy. So in the cases where you have a tell or demand for information that hasn't been addressed, I know myself in the past, I would try to get the arbitrator to resolve it. But many arbitrators, some arbitrators would tell me, well, you really should go to PERB on that. But going to PERB, if you have a grievance is suspended without pay and waiting 2 years on a decision before you can proceed just doesn't work. Well, now we're going to try to speed that up for you. There is I think I've mentioned this some, but our case management system is essentially broken, and we're trying to get a new one. We're working on an electronic filing system, and I thought that would be fairly easy to get done, but to be honest with you, it's like I'm trying to do a Mars landing here. We're working on it. I keep poking at it. The IT people, in fact, we have a meeting this Friday morning. I was initially told that we could get it by the end of the year. That's still my goal. That's by the end of not this year, 2024, 2025. That is still my 2025. That's our goal. That's what we want. I mean, there's no reason we don't have a system like you see with the federal courts or the state court system, the federal court system too. The education department teach system. I know the EEOC has this system. Everybody's got a system where, you file stuff, there's a portal and you file it and all that kind of thing goes into a system and you can access it easily. That's what we're working on. But as I say, it's gonna take some time. So those are, I have a question here. There's a situation where, okay, I have a question. I just see there's situations where NLRB ALJ, can I say sum up, no briefs. Can you consider rulemaking to do analogously? Is that the word? We don't have to do a rule on that. And maybe this question came in before I had my discussion about that, where the ALJs are now instructed to accept summations if that's what people want to do. So we're okay on that in terms of that question. Now, I've been talking about what our priorities are in terms of management to make things smoother. And faster and more efficient. And those are the things we're talking about here. And it's an ongoing conversation. If anyone has any suggestions or thoughts on that, if there's something we implement, I don't think there is, or there could be based on what I've just described. I don't see how there could be, but if there is that somehow you think is a bad idea or works badly in a particular case, we're all ears. If you send an email to the PERB info email that's on our website, I will see that eventually. I don't typically go in, but I have a bunch of staff people who go in and they bring these things to my attention. And we've had people send in requests, whether it's the status of a decision or whether it's a policy issue or whatever it may be. Feel free to use that. We welcome those responses, those questions, and we will respond. Someone, the appropriate person, will respond probably after I've assigned it to them. Now, you'll see among your materials, what I did is, because when you, having been an advocate and then coming in and, getting to look under the hood, so to speak, I frankly was fascinated, was very interested in understanding how some of these things work. What's going on under the hood, so to speak. And I know what I would always do in cases, and I figured it was the right thing to do, but I was curious as to what are the things that the staff here find useful. Oh, somebody just emailed me, when do you anticipate getting a general counsel? October 21st is the answer to that question. I just have the questions are coming in all of a sudden. How many ALJ positions do you have and how do you feel there are enough? If not, do you have a sense of how many you would want to have? How many ALJ positions do we have? I think we have, I think we have 8, we think. I just added a new one by taking another position and changing it. And as I say, we just filled it. And I'm going to ask for a couple more in the budget based on our private sector work and based on our backlog. So I think that will be enough. I don't think, frankly, realistically, I could ask for more. But I think that'll do it. The issue we've had in the past, in addition to vacancies, we've had turnovers. So we haven't been able to use the effective number of ALJs we've had. Okay, let me just I just make sure we don't have any more questions. Okay. Are the farm worker representation cases part of the ALJ's workload? If so, is that a rationale that can be used to justify hiring more? Yes and yes. They are, and we've had a dramatic increase in the farm labor filings. Last year we had, for the whole year, we had 34 filings. And this year, for the first 6 months, we've had 64. And it's difficult. It's a new statute. The regulations are new. We're getting all kinds of litigation about it. So they're difficult issues and they're new issues. They come under SARA, the State Employee Relations Act, and the SARA reports are like from 1937 to 1986 or something. So we're working off old case law that has to be updated. But that is one of our rationales to get more ALJs. So thank you for that question. Anyway, I started in on what the staff told me would be helpful for them to get things done as smoothly as possible when you come to PERB. And as I say, there's a handout which has, there's like a 9-page handout, which I have the things that were interesting to me that they suggested. Some of you old-time litigants, it may be old hat too. I think there may be some new stuff in there for you, that were stuff that maybe it didn't occur to you that was helpful for more recent litigants. I think you'll find, I hope you find it helpful. Now, I'm not going to, read through that, but I'm going to just highlight a couple of things and mention a few things maybe I didn't put in there. And just start with the filing. It's funny, I didn't put this in there, but a lot of the ALJ said, can people just make sure they recite the elements of whatever they're claiming? So like if you have a B charge or something, which is a little different, just look up an whole case and then make sure you have the elements. If a more common thing, let's say a reassignment of your work case, put that, what the work is, describe the work, that it was, exclusively done for a certain number of years, that the issue's not covered by the contract, that there was work done by non-unit employees, and, to give out the specifics, it was done without prior negotiation, the simple elements. And that goes for all of them. Make sure that they're in there, because, the thing is, when you file, and this is sort of obvious, when you file a charge, you don't want to get bogged down in a deficiency notice. And, the public sector notification, the other side gets a copy of a deficiency notice. So, I mean, make sure you have it complete and file it. Now, an issue that comes up is sometimes people treat the PERB filings, it's just the opposite of NLRB practice, generally speaking, where the NLRB, you just file a very short statement. But here we require more, but we don't require that much more. So what I mean by that is, it doesn't have to be, exhibits A through Z. We prefer not to have that, actually. If it's, let's say it's a alleged change in or a change in past practice or something. Let's say it's a memo that does it. Attach that. That would be helpful if it's, pertinent to the issue. But we don't need a full copy of the collective bargaining agreement, generally speaking, unless for some reason that's an issue. Just give us what we need, and not that much more. And another thing, surprisingly, and I'm sure you folks have had this come up at times, make sure just before it goes out that all the T's are crossed and the I's are done, because again, it's just, it makes more work for everybody and delays things if it's deficient. Now, in terms of the answers, a state court action answer, or a federal court action, where it just admits and denies and then has, violates, or the statute of limitations is expired, all these other issues, the affirmative defenses. That is not helpful. That we require that facts be put out in the answer. So the most helpful thing, it's not a rule requirement, but if you just have your admits and denies, which are important to narrow the issues, but also, and this isn't, again, like you would do a court answer, but not a numbered, essentially, statement of what you're actually claiming. Let's say the reassigning your work thing. This is, you would allege this has not been done exclusively if you're an employer, of course. For instance, whatever it is, road paving has been done by outside contractors, give the specifics. And a good way to do that is just say, as in for the response, and then lay out the facts. The same goes with the documents, if they're relevant, if you have invoices or something. But it's the documents, as the old time litigants know, that are attached to a pleading. They're not even if the exhibits are made, even if those documents, those pleadings are made exhibits during the hearing, which they probably will be, they're not considered evidence for the purposes that you want them to be. So they're just going to be admitted as evidence later on. So anyway, because now remember, the ALJ is going to have the charge and the answer, and she wants to, or he wants to know, he wants to understand what the case is about. And the easier you make it to understand by writing it easily, the better it'll be, presumably, for your position. Sometimes not. Anyway, that's another story. And now, moving on, in terms of the conferences, presently, right now, all the conferences in the state are being done virtually. There's some ALJs, I think, are using the phone, but most are doing it virtually. And the ALJs ask that when you have a conference, have someone there who is knowledgeable about the facts. I know I would have a case as an advocate, and I never, if I thought I knew the facts, but then when the ALJ said, well, what about this? I mean, you have very superficial, no matter how involved you are, you still have a superficial understanding of what happened because you're not at the work site. So if you have someone there who knows something, that helps the whole process. And not only that, if you have someone there who has some authority, you can get a lot done in the conferences. Now, I got a question. So are you suggesting that the answer should or should not have attached documents? If it's the same thing I said as with the charge, if you have a document that's directly material, attach it. If you have a document that's background that you'd use maybe on the direct of your main witness during your case, and it'll be some evidence, don't attach that. You don't have to. But let me give you, for instance, say you're contending that the contract, it's covered by the contract. Attach that section that you say covers it, the issue, breaks or something. You have a clause in your contract. Attach that. That'll help the arbitrator or the ALJ understand exactly an issue and what language is an issue. So I'm suggesting you attach the relevant documents both to the charge and the answer, the directly relevant, but not, you're not putting your direct case on in the answer. So we don't need, as I say, exhibits A through Z. Now, going back to the conference, now, as part of the process of streamlining this, we have recommended, but not directed, that hearing officers just try to hold one conference. Now, that if somebody shows up for the conference, I mean, and the idea being is you don't want to have 10 different conferences, you never get to the hearing. But the edge is kind of in a difficult situation if you show up at the conference and you don't know what the facts are, the in-depth facts, because you don't have someone there who have the facts, have knowledge of the facts, or you don't have somebody there with authority. So those are the kinds of things that's going to result in several conferences. But we've recommended try to limit the conferences. Now, in terms of, now, by the way, there are exceptions if you want a, make sure I'm answering all the questions here. Chairman Connick, can we have free access to PERB decisions from your website, similar to how NYSLRS does it? I'm not sure what NYSLRS is. What's that, the local retirements? No. But anyway, I believe we have to pay for ALJ decisions and don't receive them very frequently. Well, that's an excellent question, and that's a question I had when I came in. And let me tell you what the bad answer is, but is the answer. When I came in, I was like, why don't we have, it used to drive me crazy at NYSET because some people, not me, would get a copy of these decisions that we charge for, that we send out quarterly to people who ask for them. We have a system, for those who don't know, where you can ask for the last months or whatever it is, decisions be sent to you, and we charge. I don't know what the fee is. I said, why don't we put them on our website? And apparently we have a contract with Westlaw where we can't do that until 2 years have expired. So, that's, I'm not crazy about that, but that's what I'm told. So the decisions on our website that are PERB, ALJ decisions and board decisions, the actual decisions, the full text of the decisions are only going to be available either if you're part of this service that we have, or if you go to Westlaw. Westlaw gets them up after, I don't know, a couple of months or so. It isn't that much of a delay, but still. And that's just what we're stuck with. anyway, going back to the conference thing, I just wanted to mention to you, they all are virtual now. I personally would like to see them all come back to in person, but I'm told the parties like it when they're virtual, and that makes sense to me. If I'm in Suffolk County, for instance, and I have a PERB case that's in Brooklyn, I'd rather not have to schlep down to Brooklyn for a conference. Or if I'm in Syracuse and I have a PERB conference and it's in Albany, same thing. So I have made no effort to direct that we go back to in person for the conferences. But this is what I wanted to point out to you. If you think that you want an in-person conference, you can ask for it, and it's up to the ALJ. But we've had in-person conferences upon request of the parties. We had one recently in a state case. Now, again, you may, depending on your circuit, you could be across the street here in Albany and still prefer it virtually. I don't know, but just keep that in mind. In terms of adjournments, it used to be that you have to request them by letter, and that rule is nixed now. You can do it by email, but before you do, talk to the other side and tell us what that position is. And this is commonsensical, but also get 3 dates from the other side and then send in your email, say, I request an adjournment, the other side consents, the other side's available on these dates. It makes it a lot easier for us and much faster if we don't have to call around and get new dates. In terms of motions to dismiss, people often make them before the conference. I don't know. Now, there's probably someone out there who's going to say that they know of a situation where this happened, but generally speaking, motion will not be considered until the conference. And you can always make it after the conference, or during the conference, tell the ALJ you're going to make the motion. It seems to me you might want to wait. Now, you may have some clients that just want you to, look like you're jumping in and making the motion. You may do that for those reasons, but just in terms of conservation of energy, you may want to wait and get a sense from the ALJ as to what they think the viability of the motion is. If you get the sense that the ALJ thinks you're wasting your time, you may want to reconsider it. You may want to do it anyway. You might also get a sense of what the ALJ wants you to focus on. Again, at the conference, if you do want to make the motion, they'll work out a briefing schedule with you then. In terms of subpoenas, you have the right as an attorney, assuming you're an attorney listening to this, I assume you probably are. You have the right to issue your own subpoenas for persons. And I would think, I never wanted to go through PERB for persons because I didn't need to go through PERB, and I'd rather control it myself. For documents, you do, if you're subpoenaing a government agency, you're going to need a ALJ, a PERB subpoena. There's a provision. Remember, there's a provision in our rules that say you can make the subpoena returnable at a date other than the hearing date. So I used to always like to make my subpoenas returnable a week before at my office, and ALJs were cooperative with that. Now some of them may not be, but the rules say you can do it. So wouldn't you rather have them ahead of time? Just keep that provision in mind. Subpoenas discussed. I don't have anything more to say about that. Now, hearings. As I say, I'm not talking about everything that's in the handout. You can read that at your leisure, but there right now for local parties, depending on the office, we're scheduling in-person hearings. We're back to in-person hearings. So if you're in Albany and it involves, I don't know, Albany County, let's say, we're gonna schedule it locally. But if it's an Albany case and when I say Albany case, it's assigned to the Albany office, and it's say it's a Binghamton case, we'll do that virtually. Now, if for some reason, and I don't know if, given that fact, I heard there was once a request, if you're in Binghamton, but you want to have it in person, ask for it, and it'll be subject to the discretion of the ALJ. The other attorney may be okay with that. I would think he might have some objections to that, but anyway, we're open to that. We're open. Now, I was looking into the possibility, once there was a time when we would have hearings in Syracuse. I think I had one in Binghamton once. Out of the Buffalo office, we'd have them in Rochester. I was looking into that and talking about reinstituting that, but with our emphasis now on getting decisions written, eating up ALJ time with travel time was frowned upon by some of the staff, and that makes sense to me. And with the availability now, since COVID, the widespread commonplaceness of virtual hearings, and lastly, the difficulty in getting suitable sites in Syracuse and some of these other places. We had some issues in the Syracuse place we used to use for hearings. I've put that on the back burner now. If people are still interested in that, and if we get a handle like I hope on our backlog and the timeliness of our decisions, we may revisit that issue. If it's something people are interested in, just shoot us a note. As I say, we're open for all sorts of questions and suggestions. In terms of exceptions, someone asked me to say this because it's a pet peeve of them. If you could give us a table of contents in your brief, it helps. So it's just a minor, obviously the rules don't require that, but we would appreciate that. Oral argument, I always asked for oral argument, or at least I thought I did, and I never got it. And the fact of the matter is the board seldom grants oral argument. I was told the number is 1 or 2 times, every 1 or 2 years. So if you ask, you probably won't get it. We only grant it when we're really kind of trying to figure an issue out and we're having some trouble with it. So if it's granted, that's depending on what side you're on, that might be a good sign or a bad sign. I am told, though, that it can be helpful. As an advocate, I always wonder, the judges, particularly the appellate division, sometimes when you go up there and you argue and they don't ask you any questions, it's like, what was that for? The board, though, it can have an impact, and this example may or may not dissuade you, which is whether you want it, but I'm told that a few years ago, there was a decision where there was a case where an advocate made a crucial concession, which was very helpful to the board to deciding the issue. So, if he hadn't orally argued it, there wouldn't have been the concession, which maybe the board would have came out with the same decision. But anyway, it can be very helpful if you can get it. Finally, I'm going to turn my attention just quickly to injunctive relief, and what I want to say about that is, the rules are complicated, and so follow them carefully. And our counsel's office likes to get questions about them so that it's done right, and likes to get a heads up ahead of time because we have statutory deadlines that are very tight. So if you're going to request injunctive relief, if you call our counsel's office and tell them and give them a heads up on sort of what the case is about, they will help you and they won't help you, but they'll give you suggestions. Maybe suggestion is not the right word. They will want to to assist you in making sure technically you file the right papers in the right way. So now in the handout I gave you, every division, every department here, I gave you the number, whether it's for filing or for injunctive relief or the for exceptions that generally deputy chair. They're all you have the numbers in the handout, and we welcome calls and we'll respond to calls and try to be helpful. Whatever side you're on, whatever issue you have, in terms of technical filing, obviously we're not going to help you in the substance of the case. In terms of injunctive relief, because it's so complicated in terms of what the technical rules require, be sure to file. And again, I mean, what you want is you want us to be giving thoughtful attention to your issues. So the more time you can give our people to look at your papers on either side, you know, heads up is appreciated by our counsel's office. Now, PERB historically has been difficult in terms of finding irreparable harm. And I didn't realize this, but from 2002 to 2010, we would have our decisions of counsel on the issues of injunctive relief. And when we found it was appropriate for us to go to court or to give the free ticket, so to speak, to go to court to the parties, we had our decisions in the PERB reports. And then for reasons that I don't quite understand, and as of 2011 up to now, we stopped reporting those, but we're going to be reporting them again. So if you have an issue, you can research whether it might be something that we would take. So just keep that in mind. So I've been rambling on for an hour or almost an hour, 55 minutes. Let me see if I have any questions, any more questions. Okay, I think I've answered. Oh, and someone wrote, any comments for the benefit of arbitrators who are listening? Any comment for the benefit of arbitrators who are listening? I think our conciliation department is, I think it's working pretty well. And if you guys differ, if there's some lacking aspect of it that you want to bring to my attention, I would be pleased to hear it. We have a system now, we're putting that into our new case computer management system as well, in terms of how we assign things to get things out. But I can't think of any specifics. So one thing I will mention for arbitrators, some parties have they want in-person hearings, and there are a lot of arbitrators that prefer virtual hearings now. So we're probably going to make a change. We've been talking about making a change to put on an indication somewhere on your arbitrator profile or whatever we call it, as to whether you're agreeable to in-person hearings, and perhaps if so, maybe where, because you may be agreeable locally but not traveling farther. So that's just one thing, because like the old timers like myself, we we prefer in person. I prefer in person. I think there are good reasons for it, but arbitrators, I've heard arbitrators say it really doesn't make a difference in terms of credibility. That may be true, but when I was an advocate, I used to like to have the person across from me when I was questioning. I felt like I had more control over the situation than if they're on the TV. So, I mean, they're just a lot. I also think for a lot of reasons, I prefer in person. Labor relations, you want to see the people and get a sense of it. But anyway, that's just one change, because, as I say, counsel have been asking about that. So do I have any other questions? I don't have any other questions. I hope this has been somewhat helpful. As I say, if you have issues, questions, comments, on our PERB website, we have a new PERB website that just went online a few weeks ago. We have a email address, PERB info or something. questions, comments, policy issues, you send them to us. We will respond to them. And we're all ears. And that's about the size of it.
Thank you, Tim. Thank you for lending your time to be with us today at today's program. This now concludes the program. All attendees should return to your learning dashboard and complete the evaluation report for today's program. We thank you for choosing New York State Bar Association CLE programs and enjoy the rest of your day.
Thank you very much, everyone.
Thank you.